Under heading for to be mentioned, item 1 CRMP 3366 of 2024.
There is an error in the date.
There
is an error in date. Date में error हो गया इसमें.
अच्छा डेट
इसलिए to be mentioned में.
हम तो दूसरा चीज बोलना चाह रहे थे.
क्या?
उसमें हुआ क्या डिवीजन में सरेंडर सर्टिफिकेट देना.
मैं अब तो कुछ
ना वो डिसमिस हो गया तो उसके लिए जो रेस्टोरेशन हम दिए थे तो अब हम भी कह रहे हैं अपने से कि पिटिशनर हैज नो इन इज नॉट इन माय कॉन्टैक्ट आई ट्राइड माय हेक्टिक.
कोई बात नहीं. CRMP number 3366 of 2024. This matter has been listed at the instance of the office, mentioning that there is a typographical error in order dated 2012-2024, whereby the next date has been fixed as 7/2/2024 instead of 7/2/2024. Can the office know? Order dated 2012-2024 is hereby modified, and the next date is directed to be as the next date is modified and is directed to be 7/2/2025 instead of 7/2/2024. Office to carry out necessary correction and close this case on 7/2/20. आज ही
7
ठीक है कोई बात नहीं. और कुछ नहीं. Office to carry out necessary correction. Since today is 7/2/2025, office shall take appropriate steps for listing of the case.
Under heading for orders with effect, item 2 Contempt 864 of 2024.
Yes. आपका डिफेक्टिव पिटीशन है.
रिमूव कर देते हैं.
आपका तो रीजन ऑर्डर लगा हुआ है. क्या बोलना है?
इसमें रीजन ऑर्डर पास नहीं हुआ है. स्टिल पेंडिंग बिफोर द कैबिनेट.
शो कॉज देखें.
नहीं, शो कॉज जो है आई हैव नॉट रिसीव्ड द शो कॉज.
आपके ऑफिस से किसी ने रिसीव किया है. एक के कुछ करते हैं. ऐसा तो आप नहीं बोल सकते हैं कि यू हैव नॉट रिसीव्ड इट. देखिए Contempt Civil 864 of 2023. Counsel for the appellant. क्या डिफेक्ट है इनका केस में? Why is it defective? You filed your show cause, right?
Well, luckily this is not for my office.
Counsel for the appellant pays for and is allowed time till 28th of February 2025 to remove the surviving defects by way of last emergence. Post on 4th of March in the subsequent process.
Item 3 token number FA 6708 of 2024.
The token number is
Defective.
FA number 6708 of 2024. In spite of order dated 14/1/2025. The defects have not been removed. However, IA number 1454 of 25 has been filed seeking extension of time to for removal of defects.
they are poor persons so that all defects have been removed, court fees has not been paid. So, my lord, only 4 weeks further time, my lord. That's for the purpose I am.
You prayed for 8 weeks time. You want 4 weeks?
But they are coming within 3 weeks, my lord. That's why, my lord.
Considering the interlocutory application, time till 28th of March it is granted to the applicant to remove the surviving defects. Then,
Deeply.
if the defects are removed within time, post on 3rd of April
Deeply.
and aggravated.
Under heading for admission, item 6, Contempt Civil 1071 of 2023.
Yes.
Orders charge.
Then, yes. Petitioner.
Your petition on the lost occasion time had been granted for having no compliance. No compliance with all this.
Where is the respondent? Yes. You have not filed your affidavit. Applied.
My lord, this is not. Your lordship will
Please
pass
don't
over.
stand when it is not yours. Because I'll ask somebody new.
We'll just call the law officer. Your lordship just passes over to 1 or 2 cases. That's just all.
It says passport at 12 o'clock.
Item 7, Contempt Civil 784 of 2024 along with item 8.
Last order में कांडे भी सुन.
Ready with your lordship.
Ready means?
मतलब फाइल करने के लिए तैयार है बट फाइल नहीं कर पाए.
ये
छठा बार टाइम हो. लास्ट order.
आज ही ये कर दें.
Last order 24th of January.
क्या आज ही क्या कर देंगे? क्या कर देंगे आज?
Passover.
कौन ऑफिसर है जो आपकी बात नहीं सुनता? आप बताइए उनको कोर्ट में बुलाते हैं. बताइए. Who is the officer who does not listen to you?
ऑलरेडी तैयार है. Passover.
तैयार है तो क्यों नहीं फाइल किए? फाइल करिए. हम पास ओवर कर रहे हैं. फाइल करिए. राइट. ब्रिंग इट टू द कोर्ट. कितना बजे रख दें? कितने बजे?
12:30 या 2 बजे के
4 बजे. और अगर जल्दी बोलेंगे तो 6 बजे रख देंगे. 4 बजे आएंगे.
Item 9, Contempt Civil 68 of 2025.
Yes. Mr. Manish was here. Where is he? दूसरा केस में अपीयर हो रहे थे. अपना केस में कहाँ चले गए? दूसरे के चक्कर में अपना हालत मत खराब करना. Yes. What do you say? You file an affidavit.
My lord, the show cause, the DC is here right now. But I was praying for this to be listed tomorrow, your lordship. I want some changes made in the show cause. I have sent for some more records. The DC is in my chamber as I address your lordship. So if your lordship puts it up tomorrow, I will finalize the show cause and get it filed.
I'll post it next week.
My lord, I will.
Contempt case civil number 68 of 2025. The learned counsel for the parties are present. Mr. Manish Mishra, advocate for the opposite party, has submitted that the deputy commissioner has already come to this court, but before filing supplementary show cause. He wants to have more discussion with him.
Right.
He submits that the show cause will be filed positively by Monday.
Right.
Post this case on next Thursday in the supplementary request.
Under heading for hearing, under order 41, rule 11 CPC, item 10, SA 115 of 2020.
Lord, sir,
Yes.
may prayer of the plaintiff or appellate is that
Just a moment.
Lord,
I have seen your record. 5 जनरेशन का आपका जिनोलॉजी चार्ट लेके आइए, ऐसे नहीं हो सकता। 2 कॉन्करेंट फाइंडिंग है, क्वेश्चन ऑफ लॉ ढंग से बनेगा तभी ढंग से आपका केस डिसाइड होगा, और नहीं होगा तो नहीं बनाएंगे। लेकिन आप ठीक से जिनोलॉजी लेके आएंगे और जिनोलॉजी में पूरा चार्ट बनाएंगे, किस स्टेज में कौन सेल डीड एग्जीक्यूट किया है, 4-5 सेल डीड की कहानी भी है इसमें, ठीक है। और बेसिकली जो हमको लग रहा है कि प्राइमरीली एक आदमी के डेथ से रिलेटेड कुछ इशू है कि वेदर शी डाइड इशूलेस और वेदर डॉटर वाज देयर। आई वाज ट्राइंग टू लाइक मेक द जिनोलॉजी ऑन द बेसिस ऑफ, थोड़ा सा दिक्कत हो रही थी। आप जिनोलॉजी बना के देखिए एकदम अच्छे से, पूरा अच्छे से जिनोलॉजी बनाइए, सेल डीड कौन कैसे कैसे एग्जीक्यूट किया है, और आपका सब्सटैंशियल क्वेश्चन ऑफ लॉ भी बहुत सही से नहीं बना। इसको थोड़ा रिविजिट करके रीफ्रेम अगर करना हो तो करके लिख लीजिए, ठीक है। किसी से कंसल्ट करना है तो कर लीजिए, ठीक है। ओके, ऐसे नंबर 115 of 2020. Counsel for the, I mean, in this case, the genealogy of more than 2 to 3 generation has been is subject matter of consideration. Counsel for the appellant is directed to make the genealogy in a tabular form and also give the details of the various sale deeds which are involved in the residence. एक हफ्ता में हो जाएगा?
2 weeks.
Post this case on Thirteenth of February.
Item 11, 2nd April 282 of 2023.
Password for few questions. Yes, number 1 that we discussed.
ठीक है, 12 बजे।
Under heading for hearing, item 12, FA 176
This
of
is not
2020.
a joint compromise petition. As agreed minute in the last date, we have already filed. Except earlier minute, already he instructed me to give 3 months time to pay the repay, but it has been extended to 4 months. They have agreed and
Acceptable?
Yes, prior to records the entire
we have
compromise.
terms and conditions have been incorporated in paragraph. Page 3.
IA number 1422 of 2015.
Small d is the ultimate.
Shall upon payment withdraw the instant appeal.
Withdraw the execution case, Your Worship.
E में देखिए क्या लिखा है?
E. And this appeal will be withdrawn after payment.
So it will remain pending.
So it's better to keep it pending because track में रहेगा ना कि payment हुआ है कि नहीं हुआ है. और if Your Lordship so wishes, it can be
It
disposed
can be
of.
मेरा
set
विषय
aside.
थोड़ी, हम तो मेरिट पे डिसाइड करते हैं.
क्योंकि एग्जीक्यूशन केस भी तो पेंडिंग है ना. जब तक ये पैसा नहीं देते हैं, it will not be safe for me to withdraw the execution case.
Adjourn कर देते हैं.
It can
पेमेंट
be
लेके
set
एग्जीक्यूशन केस विड्रॉ करके
Withdraw करके
आइए,
आ जाएंगे.
तब अपील आप
Better.
विड्रॉ कर लेंगे.
बिल्कुल,
That
वही
would be
सबसे
better.
अच्छा.
better. Both sides will be in safe side.
Safe side.
FA number 176 of 2023 with ID number 14422 of 2025. A joint compromise petition has been filed. The learned counsel for the parties have jointly submitted that the matter will be listed after 6 months.
4 months.
4 months तो ही है.
After 5 months.
After 5 months.
After 5 months, and by that time, the respondent would also withdraw the execution case if the appellant abides the
Terms of
terms of the compromise, and upon
Especially-
withdrawal of the execution case, the appellant would withdraw the appeal this first appeal itself. यही है ना?
appeal can be disposed of in terms of compromise at that
ये
time.
execution case withdraw कर लेंगे तो काम खत्म हो जाएगा.
उनका claim
Or the appeal can be disposed of in
Yes,
terms
yes.
of the compromise.
it will be.
The counsel for the respondent has also submitted that if the terms of the compromise are adhered to by the appellant, he shall also file an affidavit enclosing herewith the order sheet of the execution case. That's it.
In the meantime, he will not proceed
And
with
not
the
proceed in
execution.
the execution.
That
He
should be
undertakes that he shall not proceed with the execution in the meantime. Pose this case on 15th of July in the supplementary cost list for appropriate orders.
Should be treated partner so that it is listed before the
It
execution.
will be better,
It would be better if it treated as part.
कोई जरूरत नहीं, कहीं पर नहीं आप करेंगे हो जाएगा.
हाँ, हो जाएगा.
ऐसे पाठक करने का क्या ही
अच्छा,
पता है.
ठीक.
कुछ
ठीक.
कोई हियरिंग नहीं किए हैं.
नहीं ठीक है.
कोई भी कोर्ट डिस्पोजल करे इससे
हाँ,
क्या ही
वो तो
फर्क
होगा ही.
पड़ता है.
ऑर्डर शीट देखने पे तो बिल्कुल डिस्पोजल करेंगे.
12th July.
लास्ट ऑर्डर भी ठीक से
15th.
लिखा हुआ है.
15th.
उसमें भी आपका पैसा
ठीक
मिशन.
है, कोई उसमें दिक्कत नहीं. 15th.
15th July.
From the daily list, under heading for final disposal, item 1, second letter 157 of 2019.
Yes, appellant.
One week time, below, I was not feeling well, below. I was suffering from cough and cold, below. And
SA number 157 of 2019. Mr. नाम बताइए अपना. आशुतोष प्रसाद जोशी
so that I can
has attended the court proceedings online and has submitted that he is not well and he has not come to the court. Correct?
yes, below.
You have not come to the court? Have you
No,
come?
like online. I'm from home. I'm joining.
And he has not come to the court. The matter was adjourned by way of last indulgence by the order dated 23/1/2025. That too upon payment of cost. But today on medical reasons, the counsel for the applicant is written. Post on next Thursday in the supplementary cost list. अब एडवांस आप सर्कुलेशन में मत दीजिएगा. जिस केस में इस तरह से ऑर्डर होता है बाय वे ऑफ लास्ट चांस, उसमें एडवांस नोटिस सर्कुलेशन का देने से कोई फायदा नहीं है.
It was my responsibility कि वो फाइल पढ़ के I was seeking adjournment.
No problem about it. No problem about it at all. Next week कर लेंगे ना?
जी हुजूर हम कर लेंगे. आज भी हम थे. लेकिन मेरा कंडीशन नहीं लगातार स्पीक करने का.
अरे आपकी तबीयत ठीक नहीं है तो आपकी तबीयत से बड़ा ये केस थोड़ी हो जाएगा. ठीक है, इसलिए आप नेक्स्ट वीक आइए, कर लेंगे. In supplementary cause list, the matter would be there. Okay?
Yes.
In supplementary cause list.
Yes.
Under heading for orders with effect item 2, FA 76 of 22 along with item 3.
IA for example, remaining limits. IA number 156 of 2020.
156.
Yes. IA.
Which defect are you seeking?
Defect number 2 and 9 are the remaining defects.
What is defect number 2?
It states a certified copy of the award of reference case number 9 of 1989 with authentication fee of ₹10. And defect number 9 says date of award is missing in para number 1. I have stated in para 4 of the same IA that the said reference case was dismissed and therefore no award was prepared. And I have also applied for the same, which is stated in para 5 below. I have applied to the board below, but the requisition which I have received states that the award is not available. I have annexed the same. So I am only saying that these two defects may be ignored.
You have not filed a certified copy of the award.
Your Lordship, award was never prepared since the reference case was dismissed.
Even if no award, some decree is prepared. What is
Yes,
the?
Your Lordship, that nil award is prepared, but in this case, no such award was prepared. I have annexed the requisition in this. Kindly see annexure IA1, page number 8. This is page number 9.
Award has been passed by?
Award was not prepared. Judgment was passed by learned civil judge to senior division Survey.
FA number 76 of 2022 with IA number 156 of 2025. Learned counsel for the applicant has submitted that the interlocutory application has been filed seeking ignoring the defects, that is defect number 2 and 9, which are as follows. इसको कोट करेंगे इसमें से IA में लिखा हुआ है पैरा नंबर 2 में. Rest of the defects you have removed?
Yes, sir.
She submits that the remaining defects have been removed. The learned counsel submits that the reference case, in the reference case, no award was ever prepared. And even nil award was not prepared, as the reference case was itself dismissed. Office is directed to call for a report from the concerned court regarding the aforesaid submission made by the learned counsel for the applicant. office is also directed to call for the records.
Already called for.
Are we? Just come.
Yes, LCR has been received.
Where is it? Have you checked that there is no such award? Who will check that?
Your Lordship, the other case, this one was FA 152, Your Lordship, I checked.
You can ignore the defects. Okay. Any objection to this IA? The learned submission के बाद लिखी है, the learned counsel has also submitted that the records have already been received from the concerned. Considering the aforesaid submission, the defect in condition with defect number 2 and 9 are ignored for the present. और बताइए क्या?
Your Lordship, ended after 4 weeks, Your Lordship. Since in this case, senior has been engaged, but recently he met with cardiac arrest. So,
Sorry? Yes?
Alkali counsel Mr. Arvind Kumar Sinha, Your Lordship. In this case, he has been engaged, Your Lordship, and recently he has undergone heart surgery. So, can you just bring 4 weeks, Your Lordship? So, final hearing, any date after 4 weeks.
There are other surviving defects, defect number 2 and 9. Admit why?
Yes, ma'am. Your Lordship, on 14
Since the defect number 2 and 9 have been ignored, there are no surviving defects. The case has already been admitted by the order dated 14/8/2020. Counsel for the appellant prays for 4 weeks' time. Submits that the matter be posted after 4 weeks under appropriate review. ठीक है, post after 4 weeks. बताइए post on 26th March. Next. The same, other is also the same.
Yes.
IA
That
file.
is different, different field.
This is difficult.
That one is already admitted. LCR also received.
There is one case which has been dismissed,
Yes.
75 of 22.
Your Lordship, in that case, Your Lordship, since the judgment was passed against dead person, on that ground it was dismissed.
No counter affidavit has been filed. You were supposed to file any counter affidavit. Yes? Fine. There are repeated direction to file counter affidavit. There must be some by which order they were directed to file
Your
counter
Lordship,
affidavit.
27/7/2023. No, Your Lordship, 11/8/2023. In FA 152 of 2000.
petition आप लोग करते रहिए, ठीक है? Batch बनाइए, फिर एक केस dismiss पर default करा दीजिए. This is the fate of these first appeals. Generations बदल जाते हैं. They don't get the fruits of litigation because of the councils. Why did you get one case dismissed for default?
It was not dismissed for default.
Yes.
In FA 150.
FA 75 has been dismissed.
Dismissed, Your Lordship, on the ground that judgment was passed against dead person.
So, if judgment was passed against dead person, then the appeal would have been allowed. Why dismissed?
Your Lordship, it was dismissed with direction to the appellant to go before the court below and make representation before that, so that the name of the legal heirs of the dead appellants may be incorporated in the judgment.
FA number 152 of 2012 में लिखी. As per the office note, the counter affidavit has not been filed. Counsel for the state submits that prior to the next date, counter affidavit will be filed.
For admission, item 7, contempt was 069 of 2023.
Only found out modality 24-1 at Paris 6. Opposite party number 2 have been directed to Paris Showcase.
Yes,
I yesterday.
But they have definite LPA after 2 years of the past and 1 year, it's more than 1 year since the contempt.
when did you file the LP? Yesterday. When did you file the LP?
LP ma'am. Twenty-fourth of January.
There is no filing from the immigration.
फाइलिंग नंबर बताइए. What is the filing number?
I was taking Passover for one case, one or two cases.
For hearing under order 41 rule. Item 8, second appeal 481 of 2016.
Where is the appellant? कॉस्ट लगा के 10 हुआ है. आप डिसमिस कर देंगे इसको. I'm sure somebody must be hearing it through net. श्रीजी चौधरी का नाम डाल वही अपील कर रहे हैं. Mr. Shiji Chaudhary and Mr. Dr. H. Bars. आप हैं? Respondent. बताइए क्या बात. कोई बात नहीं, आप आइए, क्या फर्क पड़ता है? You can assist the court as a counsel. बताइए, पढ़े हैं कि नहीं पढ़े हैं फाइल? फाइल एडमिशन पे तो फिर क्यों ही अपीयर हुए? अपीयर नहीं होना चाहिए था ना? ऑफिस का नाम आ रहा था. ऑफिस का नाम तो इसलिए आ रहा था क्योंकि आपने वकालतनामा फाइल किया होगा. You are watching counsel. ऐसा कोई क्लियर लॉ नहीं है कि रिस्पोंडेंट को नहीं सुन सकते हैं फॉर द पर्पसेस ऑफ फ्रेमिंग अ सब्सटेंशियल क्वेश्चन ऑफ लॉ. बाद में आके बोलना कि ये गलत हो गया, ये हो गया, उससे ज़्यादा अच्छा है कि सुन के फ्रेम कर दें. क्योंकि ऐसे बहुत सारे मैटर्स आ रहे हैं, बाद में काउंसिल इज अपीयरिंग, देयर इज अ प्रोविजन दैट यू कैन से दैट इट हैज बीन रॉन्गली फ्रेम्ड, बट देयर इज नो हार्म इन हियरिंग अ पर्सन एंड देन फ्रेमिंग द क्वेश्चन, इजंट इट? रिकॉर्ड्स तो अपने पास होते नहीं है, एनसीआर में नहीं रहता है इससे. इतने सारे पार्टी हैं, इसको डीएफडी कर देंगे तो रेस्टोर मेरे लाइफ टाइम में तो नहीं होगा. इसको पास ओवर करिए और मिस्टर आप जब आप अपीयर हो ही गए हैं अदर साइड को खबर करिए अपीयर होने. ठीक है, इतना तो करेंगे ना.
Item 9, second appeal 62 of 2017.
अच्छा, इसमें एडजर्नमेंट है. मिस्टर कुंदन कुमार बच्चा कहाँ है? कोई एडजर्नमेंट रिक्वेस्ट मत लिया करिए. कॉस्ट दे दे के एडजर्नमेंट होता है, उसके बाद एडजर्नमेंट रिक्वेस्ट दे देते हैं.
Manoj, in this case so far,
आराम से मिस्टर प्लीज हैव योर.
actually in all courts appeals are being heard. In court number 4, this court number 24.
You should be happy about it.
No, I am happy. But in this case, appellant number 4, appellant number 4 and appellant respondent number 6 died. Therefore, I have to file. Yesterday, I got the instruction when I called at Sahibganj.
Yes.
Therefore,
AC number 481 of 2016. The learned counsel for the parties are present. आप सारी respondent की तरफ से हैं? नहीं पता. आपको नहीं पता आप किसकी तरफ से हैं? और आपके कोई सिस्टम नहीं है आपकी फाइल में नोटिंग का? किसकी तरफ से आप हैं?
hello, I have got the information that appellant number 4 died on 30/9/24 and respondent number 6 died on 23/9/24. I therefore very humbly request your ladyship.
30/9 को कौन मेरे? अपीलान नंबर 4.
Appellant number 4.
And respondent number 6.
23/9/2024 को.
Essay number 481 of 2016. Learned counsel for the appellant submits that appellant number 4 has expired on 30/9/24 and Respondent number 6 has expired on 23/9/2024 and he has got this information only yesterday. He prays for adjournment. अब एक point भी है इसमें,
I will file petition along with limitation.
limitation या जो भी आप सारा
जी,
negotiate
जी।
के साथ कर रहे हैं। Post on 20th March.
Much obliged. Sorry for the
Very
delay.
good.
I am
As-
extremely sorry.
Sir, second appeal dismiss करने का मतलब है आप केस dismiss करें।
Right. बहुत दिक्कत
उसको
होती है।
restore नहीं करवा पाइएगा
हाँ।
जितने parties हैं।
हाँ, दिक्कत
इसलिए
होती है
I am
बहुत।
not interested in dismissing case on for default. But yeah, adjournment होने के बाद मतलब cost पर adjournment होने के
इसमें
बाद
भी
भी लोग नहीं
जितना
आते।
बार योर लेडीशिप जितने बार कोशिश करते हैं कि अब जो है इसको करेंगे, फिर आता है इतने पार्टीज हैं कि ये मर गया वो। हम तो लास्ट 2-3 साल से सब्स्टिट्यूशन नहीं करते हैं। आई एम एक्सट्रीमली सॉरी फॉर दैट।
For orders में रखेंगे, है ना? For orders में आएगा ये। चलिए next case।
Item
Much
9.
obliged.
आपको लास्ट टाइम कॉस्ट देकर एडजर्नमेंट हुआ था, अभी आप एक सर्कुलेट कर दिए हैं एडजर्नमेंट नोटिस, इसका क्या मतलब?
अगला सप्ताह
नहीं, अगला हफ्ता तो कॉस्ट से adjournment, ये तो गलत बात है ना?
कॉस्ट
नहीं, आप जो इस तरह से एडजर्नमेंट स्लिप सर्कुलेट कर दिए हैं, ठीक है, और तो हम तो आप एडजर्नमेंट स्लिप लेना बंद कर दीजिए। एक भी पार्टी का एडवांस एडजर्नमेंट नोटिस मत लीजिएगा, क्योंकि यहाँ पर कॉस्ट से एडजर्नमेंट होता है, फिर भी एडजर्नमेंट स्लिप देते हैं। ये तो नहीं हो सकता। ऐसा
कल
नहीं है।
कल रख दिया।
कल आपने देखा है? आई एम नॉट सीइंग टुमारो। ये बात सही नहीं है। आप सेकेंड हाफ में करिए, हम इसको एडजर्न नहीं करेंगे।
कल रख दिए।
नहीं, कल
एक
नहीं।
एक दिन के लिए एडजर्नमेंट कर दिए थे। कल रख
आपको
दिए थे।
बोले ना, कल आपने देखा है? नहीं देखा है ना?
नहीं, हम तो
मैंने भी नहीं देखा।
कल रख दिए।
नहीं, कल नहीं रखेंगे। आप आइए सेकेंड। टुमारो दिस कोर्ट मे नॉट बी देयर, इसीलिए बोल रहे हैं कल आपने नहीं देखा।
सोमवार को
सेकेंड हाफ में आप आइए।
Item 10, second appeal 204 of 2018.
यस, अपीलेंट नेक्स्ट डेट नहीं होगा। कौन सा केस करेंगे ये बताइए। आपका केस एडजर्न करेंगे तो आपके बाद वाले को कैसे मना करेंगे? नहीं होगा। फाइल खोलिए और पढ़ना शुरू।
इसमें मिस्टर श्याम सुंदर प्रसाद पुस्तक कुशवाहा जहाँ पर petition आई एम नॉट
कॉस्ट कितना देंगे? 50,000 कितना? पिछली बार एक साथ 1,000 रुपये कॉस्ट हुआ था, ठीक है, इसमें 1 0 तो बढ़ाएंगे हम। 10,000 से कम कॉस्ट करते को हाई कोर्ट को शोभा भी नहीं देता है ना, वो भी सेकेंड टाइम। इससे कम कॉस्ट नहीं होगा। बाय वे ऑफ लास्ट चांस, 3 बार लास्ट चांस हो चुका है, 1,000 रुपये कॉस्ट हो चुका नहीं होगा। और जिस केस में कॉस्ट ऑलरेडी हो चुका है उस केस को आज हम डीएड भी कर देंगे। अब कॉस्ट लगा के हम एडजर्नमेंट नहीं करेंगे, ये हम सोच के आए हैं। सारे केसेस में कॉस्ट लगा के एडजर्नमेंट हुआ, कोर्ट बिल्कुल खाली है। तो it is expected that many of the cases will be dismissed for default if they do not appeal. नहीं होगा, बिना कॉस्ट के एडजर्नमेंट नहीं करेंगे। देखिए, ऐसे नंबर 204 फाइल का आपका
मेरा केस ही नहीं है।
आपका केस ही नहीं है तो आप मत ही अपीयर होइए। देखिए,
फॉर्म क्या गया फोन टेलीफोनिक मैसेज
नाम बताइए।
धर्मेंद्र कुमार मल्तिया।
धर्मेंद्र, देखिए ऐसे नंबर 204 और 2018 मिस्टर धर्मेंद्र कुमार मल्तिया। Advocate submits that he has been informed by the counsel for the appellant who is on record to seek adjournment. The records of this case reveal that the matter has been adjourned on numerous dates, and by the order dated 13/12/2024, the case was adjourned by way of last indulgence upon deposit of cost of ₹1,000. Today, the appellant is seeking adjournment. However, considering the prayer, the कितना टाइम लेने बोले हैं? Considering the prayer, the matter is adjourned and is directed to be posted on 13th of February 2024, subject to payment of cost of ₹10,000 to be deposited in Advocate Clerk Association है ना, सारा कॉस्ट उसी में जमा करना है, ठीक है? उसका अकाउंट डिटेल भी दे देंगे।
उसका 2000 कर दीजिए, 10,000
एक जीरो और बढ़ा देंगे।
इसको डिसमिस फॉर डिफॉल्ट कर दीजिए मेरे साथ से, नहीं हो पाएगा, तो होगा ही नहीं, जान रहे हैं हम लोग क्या मिलता है हमें मिलता है।
ठीक है, subject to payment of cost of ₹10,000 if the prior to the next date of hearing, failing which this appeal shall stand dismissed without further reference to the bench. ठीक है, DFD करा देंगे, 10,000 नहीं जमा होगा, जब रेस्टोर होगा तो 10,000 रुपए जमा
2,000 कर दिया, जब करवा 2,000 कर दिया, 10,000।
Item 11, second appeal referred to Office 180.
Yes, appellant.
Praying for a very short Passover. My senior will argue this case. He's in court number 17 right now.
Open your file. You have read the brief?
No, ma'am.
Why?
Ma'am, I was ready for court number 9, and right now I don't have the file, so I'm really sorry, ma'am.
इस कोर्ट के इंचार्ज कौन है आपके ऑफिस से?
सर खुद ही इसको आर्ग्यू करने के लिए थे, बट राइट नाउ ही इज
चलिए पास हो।
Item 12, second appeal 360/2018.
For a very short Passover. Only 2 to 3 cases.
You just tell me which case should I take up, such that your case is passed. इतने लोग बैठे हैं, पूछ लीजिए किसको केस करना है, आपको पास होगा तो बताइए।
Just praying for a short Passover.
शॉर्ट मतलब उसके बाद हमारे पास कुछ करने के लिए नहीं है। फाइल पढ़े हैं ना?
Just 5 minutes before I get this file, I'm not aware about this.
ऑफिस में नहीं पढ़ पाते ना, यहाँ पे पढ़िए। चलिए, स्टार्ट रीडिंग। शॉर्ट पास ओवर बोले थे ना, तो उतना शॉर्ट टाइम बीत जाए। ट्रायल कोर्ट का जजमेंट।
Page number 9. From the very beginning.
Just a moment. Learned counsel for the appellant prays for Passover. The trial court judgment is handwritten and is not easily legible. the appellant is directed to file a typed copy of the judgment and decree passed by the learned tribunal. टाइप कॉपी फाइल कर दीजिए, ठीक है? पढ़ा नहीं रहा है, ऐसे नहीं चलेगा। Post on 20th February, the typed copy be filed by 13th of February.
20th of February.
By 13th, it will come on 20th. 20.
Item 13, second till 21 of 2022.
Wait, please.
Yes.
In this case, I was the defendant. I have lost in verdict. So it is the eviction suit. So the case which the plaintiff had made out before the court is, they say, Your Lordship, that they had purchased the suit property sometimes in the year 2006. In October 2006, they say that we approached the plaintiff seeking to let out that premises on rent. He gave it on rent to us on a monthly rent of 300 rupees. Later on in 2008, they filed the suit that I have been defaulting in making payment of rent and they require it for personal bona fide necessity also. This is the case which the plaintiff makes. So we file a written statement. We say that there is no landlord-tenant relationship. We say that we are in possession of the property since the year 1966. Initially, we were tenants. Later on, Your Lordship, we entered into an agreement for sale in the year 2003. And when the agreement for sale was not honored in the year 2006 itself, that is 2 years prior to the filing of the suit, we file a suit for specific performance which is pending, in which the widow of the owner died in the meantime. The widow of the owner had given a statement that the person through whom the plaintiffs claim to have purchased the property is his son of unsound mind. And that suit is still pending. So the case set up by the plaintiff that there is a landlord-tenant relationship is incorrect. We are there in virtue of our own right, pursuant to an agreement for sale, pursuant to which we were put in possession by the husband owners prior to the execution of the sale deed by the plaintiffs.
2006, they purchased from whom?
From one, I'll just give the name. One Vasudev Shah. Lordship, this property was owned by Tarini Shah. Tarini Shah was the person who entered into an agreement for sale with us. Lordship, Tarini Shah died leaving behind his widow Shanti Devi and Vasudev Shah. Shanti Devi's deposition has been exhibited as Exhibit D, wherein she has stated that my son is mentally challenged.
This Vasudev Shah is mentally challenged.
Yes.
And he is a plaintiff also.
He is not the plaintiff. Plaintiff is the purchaser from Vasudev Shah.
So you have purchased it.
So I have entered into an agreement.
You are the defendant.
I am the defendant. But so our case is that once Your Lordship, the title has been disputed and an independent claim right has been claimed on the basis of prima facie documents, learned court will ought to have converted the suit into a regular title suit for deciding. Secondly, when it had,
Where is such
Your Lordship, kindly see the judgment of the exactly on similar circumstances.
It will get converted.
It will get converted, or otherwise the court may return the plate also. Lordship, we kindly see, Lordship, we can permit me to have this copy. Yes. Lordship, may kindly see para 52 first. At the instance where the decree can be passed, will be a case where plaintiff has failed to prove relationship of landlord and tenant, but
If a person fails to prove
yes,
relationship of landlord and tenant, the
the
suit
suit
must
will
fail.
fail.
As
Suit will
simple
fail.
as that.
Lordship, may kindly come to page para 63.
Yes.
In this case, it may be noticed that plaintiff's case that the plaintiff case had been that it is he who inducted the defendant's predecessor in interest as a tenant, whereas the case of the defendant is that despite execution of the deed of sale by their predecessor, Tik Narayan Singh to Lakshman Ram by reasons of purported deed of sale dated 4/12/1968, they, means the defendants, continued to possess the suit property in their own right. The issue, therefore, which arises for consideration was as to whether the defendants came in possession of the suit premises upon their induction as a tenant. So we have produced these rent agreements also exhibited by the plaintiff when he purchased the land in question inter alia by the reasons of deed of sale dated 3/9/75, including by executed by Lakshman Ram in his favor, as also the reasons of two other sale deeds of sale from co-sharers of Tik Narayan Singh, as mentioned herein above, or the defendants had been continuing in possession without any interruption whatsoever. The learned court below did not address himself to the vital aspect of the matter at all. Here also they have not addressed. But so I have produced the sale deed of the lease deed of the year 1975.
Let us see the discussion of it.
Yes.
Where are the issues?
Lordship may kindly come to.
The issues of the trial court, para number 5.
Yes. Lordship wants to say the trial court judgment.
Of course, trial court judgment first.
The defendants appeared and pleaded. May I read out that?
Para number 5.
On the basis of the pleadings, the following issues: is the suit as framed is maintainable? Had the plaintiff valid cause of action for the suit? Whether the plaintiff is the absolute owner of the suit premises? Whether relationship of tenant and landlord exists? Whether plaintiff was bona fide requirement of suit premises? Whether partial eviction of the suit premises can fulfill the demand of necessity? Is the plaintiff entitled to the relief?
We need to see 3 and 4.
3 and 4. Yes,
Para 11.
the plaintiff, in order to prove that he is absolute owner of the suit premises and relationship of landlord and tenant exists between them and defendants denied any relationship of landlord or tenant, rather they are the owner. Plaintiff had adduced 4 oral evidences like defendants in order to prove owners that they are owner of the premises, examined 4 witnesses and documentary evidence. Firstly, PW2 plaintiff deposed that he has purchased 3D7 Jharkhand land, Basuri Khata number such and such from Basudev Shah, son of late Tarini Shah, for consideration of Rs 87,000. White sale deed number such and such dated 9/3/2006, and on 9/3/2006, vendor and his wife Kalyani Makshasa Masood Alam came to Godda court and met with Mahendra Bhagat, advocate, who dictated the contents of the sale deed written by Maheshwar Madhav. Further, Mahendra Bhagat heard the recital. Thereafter, they found correct. Further, for typing before Satish Chandra Divakar such and such, and his son brought type deed before Mahendra Bhagat, advocate, and again contents were heard by them. Further, Basudev and his wife put the signature and thumb, and witnesses Upendra Shah and Maksud Alam, but their signatures in the presence. Further, sale deed got registered in the registering office, and he had paid consideration amount of 7,000 to. It should be 87, or I do not know 7,000 is right. In presence of witnesses, deed writer, advocate, registering officer. On the basis of the sale deed, he became absolute owner and got possession. After construction of a room, he had given on rent given on rent rupees 300 per month to Khurshid Alam Mumtaz Ansari for running business. On 1/10/2006, and rest possessed by him. It was agreed in terms of tenancy. When he wants, they will vacate the premises and they will pay the rent timely. Further, he deposed that he asked the defendant in month of July to June 2008 that he will shift his ready-made shop from rented premises to his suit premises and requested to vacate the shop. They said they will vacate it in August 2008, but they did not vacate and also stopped payment of rent. Total rent is 700 rupees yet due for non-payment of rent. They became defaulter. On 21/9/2009, he sent pleader notice to the defendant, but they did not reply. Further, on 1/9/2008, defendants finally refused to vacate the room. Again, the pleader notice given by the defendant, whose reply has been given with wrong facts. Defendants have not given any money to the father of Basudev and entered into any sale agreement. Sale agreement filed by the defendant is forged, bears forged signature of Tarini Shah. In clause para 19, he deposed boundary of his ready-made against which he is running rented premises. In paragraph 20, he deposed that he cannot produce Basudov Shah, no, he is stressless. In paragraph 22, he deposed that
That's
note.
it, there are so many evidences discussed.
Lordship, only oral evidence of contrary to and Lordship, to the contrary, we have adduced documentary evidences of whatever you have said. Rent agreement, they say oral. Everything they say oral. And whatever we have pleaded, we have produced the documentary evidence. His case gets falsified from the tenancy agreement produced by us of 1975. That we were initially tenants, later on entered into an agreement for sale. Suit filed prior to the institution of this suit, 2 years before.
You entered into agreement of sale
Sale.
from the
With Tarini Shah.
Tarini Shah.
Even otherwise, if his case
That's
is
right,
also to be
with
believed.
Tarini Shah.
Yes.
And subsequently, he sold the property.
He did not sell. He died leaving behind his son and widow. Even otherwise, his son was not the absolute owner. Lordship, the son, the sale deed is executed by the son. And Lordship, the mother says that son is a lunatic. When I asked
It's a
the
registered document, okay? Mother
It is a registered document.
Lunatic बोल देने से certificate produce किया है lunacy का?
Lordship, maybe a registered document.
Lunacy का कोई certificate है?
नहीं
नहीं है फिर?
ठीक
इसका
है।
क्या relevance है?
मान लीजिए सेल डीड हो गया, बेटा सेल डीड कर दिया ड्यूरिंग द subsistence of an agreement for sale. Lordship, that is pending adjudication. We were put in possession after Lordship substantial consideration amount was paid to the father. Lordship, his case that after 10 months of purchase we were inducted as a tenant gets falsified. When we cross-examine him, where is Basudov Shah? He said, I cannot produce. He has fled away. Which also goes to prove, Your Lordship, that when mother is available at home.
You just read this. This
What
finding.
you want me to read from?
Page 18.
Page
Of the
18.
trial court judgment.
Lordship, the sentence term is admitted in paragraph
Yes,
14.
yes. Thus the plaintiff. Previous page slide.
Thus, plaintiff has corroborated the pleadings with respect to the plaintiff's notice to defendant for vacate. Plaintiff's legal notice to the defendant to vacate the house on 1/9/2008 is admitted in paragraph 14 of the WS. Yes, we admit and we have replied. Yes. WS of defendant
आगे
number 1.
बढ़िए आगे.
DW1 deposed that since 1966-67, his father Usman Ali was tenant of Tarini Shah. Suit premise was further taken on rent of ₹300 from Tarini Shah by them. In dated 15/12/2003 sale agreement Exhibit D executed by Tarini Shah. After that, he stopped payment of rent. In the meantime, Tarini Shah died and his brother Khurshid has filed a suit against Shanti Devi for execution of the sale deed. That is the suit I was talking about. He's had no relation of landlord and tenant with the plaintiff. In title suit number 17 of 06, Shanti Devi stated that his son is mentally weak. DW2 has proved the sale agreement, Exhibit A, and deposed that after sale agreement stopped payment of rent to Tarini Shah. DW4 has not seen any fact. He heard that Mumtaz is tenant since 40 years. He had no knowledge about document related to the case. DW5 deposed.
Exhibit A is dated
2003.
15/12/2003.
15/12/2003. DW5 deposed that a dispute took place with Ram Vilas. He did not see any document. Deposed hereby the facts in this veracity of witnesses not credible. जो 1966 में पैदा नहीं हुआ था तो कैसे बोलेंगे कि हम देखे थे उसमें? DW6 defendant Khurshid deposed that Tarini given suit premises on rent to his father Usman, and after his death both defendants became tenants of Tarini Prasad. Further, Exhibit A rental agreement, A, B rental agreements, Exhibit C
affidavit,
and in evidence discussed earlier. Further, the sale agreement Exhibit D. In paragraph 27, he deposed that sale agreement Exhibit D was not registered. It is settled law that unregistered sale agreement, which requires Registration Act 17, is inadmissible. Which is an incorrect position. Inadmissible, though it can be used for collateral purposes, it will not confer any right, any title, intent to any person party to agreement. Exhibit D4, DW4 deposed that Vasudev, son of Tarini Prasad, is a mad, lunatic man. Also, his mother Shanti Devi stated in written statement in title suit number 17 of 06 that her son is weak mind. On assertion that any person cannot be declared and presumed unsound mind in certain interval, he can be fit to take decisions. Defendants have not filed any document issued by competent authority that Vasudev Sahu is of unsound mind. DW1, DW2, DW6 deposed that after sale agreement, defendant stopped payment of rent. It is apparent from the evidences that defendants that Tarini Shah had terminated tenancy of defendants on event of Exhibit D. So this is the sale agreement. Rather, defendants have stopped payment of rent to Tarini Shah.
What about the appellate?
The same thing as the declared, if your lordship permits me. It starts from page 40. So the finding starts from
Page 32. Internal page 19.
yes.
And it reads, after perusal of record.
After perusal of the record, it transfers defendants as claim on the basis of sale agreement as owner of the disputed shop, whereas plaintiff claim as owner claiming shops on the basis of registered sale deed, and he filed suit for realizing due rent and also to vacate the premises for personal necessity of plaintiff, but plaintiff do not establish that he required the suit for personal necessity. He purchased the shop from Vasudev, but Vasudev do not come in the court to support the due of rent on defendant. After evaluation of the oral and documentary evidence, it transferred that PW2 had purchased the suit premises through sale. The sale deed Exhibit 1 on 9/3/2006 from Vasudev Prasad Shah, son of Tarini Prasad Shah. Oral tenancy agreement of defendant with plaintiff accrued on 1/10/2006. PW3 came and support at para 8 that he has seen Ram Vilas was taking rent from Mumtaz on 2/10/2006. PW4 has corroborated payment of rent realization from Mumtaz on 300 per month by Khurshid to Ramvilas on 4/10/2006. PW5 has supported payment of rent in December 2007 to Ramvilas by Khurshid. So in this way, PW3, 4, 5 has seen payment of rent to defendant by plaintiff in present time, which established the relationship of owner and tenant between the with relating to the suit properties. Plaintiff has corroborated the pleadings in this respect, and notice of defendant to vacate the house on 1/9/2008 is admitted in para 14 of the WS by the defendant. W1 deposed that since 1966-67 his father Usman Ali was tenant of Tarini Shah. Suit premises was further taken on rent of 300 per month from Tarini Shah on rent. On dated 15/12/2003, sale agreement exhibit
No,
D was.
just a moment. Earlier he was tenant of father, and thereafter Tarini Shah, there is another agreement of rent.
1975.
No, rupees 300 per month.
हाँ,
इसका date कब है?
1975 exhibit 1 and exhibit 2 if lordship sees.
Okay, exhibit 1
Lordship
is
तारिणी शाह के फादर के टाइम से हम मेरे फादर टेनेंट
ठीक है,
है
लेकिन उसके बाद fresh agreement
फ्रेश
है ना?
एग्रीमेंट हुआ दैट हैज बीन
कब-
एक्सिबिटेड बाय
कब-
अस
कब?
Lordship 75 I just look at it.
This is 1975.
Yes.
Let us assume it for a moment.
Lordship I'll just give the exact date. Lordship 1990. First exhibit A है 5/12/1977. Second है 10/12/1990. तारिणी शाह के साथ. I beg apology. जो 300 रुपीस वाला है. उसके बाद
She died in 2004.
yes agreement in 15/12/2003.
Okay.
Lordships
Agreement of sale.
agreement for sale 40,000 shown as advance. Lordship thereafter rent.
Was
paid.
there any stipulation that the no rent will be paid after agreement of sale in the agreement?
The agreement says, the Lordships, that pursuant to this agreement, as we are continuing, we will continue in possession. And Lordships, if he also mentions that in my absence, my wife will honor this agreement.
That's right.
Yes.
You see, there are two kinds of agreement of sale when the tenant is in the premises. First is where he agrees that I will not take any further rent.
Okay, then
And
that
here is
agreement-
a case where there is evidence of payment of rent even after the agreement of sale.
No,
Therefore-
I'm just coming to it. I'll just explain. Lordship PW5.
इसको थोड़ा सा complete करिए.
हाँ, इसको हम एक बार बता भी देते thereafter I'll complete it also. Lordships PW4 and 5, they are the chance witnesses. What they say, plaintiff के पास कोई document नहीं था.
Cross examine किए हैं.
क्रॉस एग्जामिन भी किए. लॉर्डशिप वो लोग क्या बोलते हैं, एंड लॉर्डशिप नॉर्मल सर्कमस्टेंसेस इम्पॉसिबल. आई वेंट टू हिज शॉप टू परचेज समथिंग. आई सॉ हिम पेमेंट ऑफ पेइंग रेंट. लॉर्डशिप आई पुट अ क्वेश्चन टू माय सेल्फ. व्हेन वी गो टू द शॉप, मेनी पर्सन आर सीन मेकिंग पेमेंट अदरवाइज. हाउ डज अ पर्सन नो that I was as a tenant am tendering a rent, that too he will count while I am tendering it to somebody else. These are the chance witnesses. They neither know the parties. It is admitted fact what I am saying, because I am in the second offense. They say that I am simply a customer. I went to his shop by chance. There I saw. And we have produced documents that there was no necessity to pay rent. We were already in possession.
No, there is a necessity to pay rent. This law you cannot say.
Lordship,
Merely because there is an agreement of sale.
yes.
The liability to pay rent
Yes.
does not cease.
Yes. Lordship, I go down what,
Unless there is an agreement to that
Lordship,
effect.
whatever is current for Lordship, what do we accept it for a moment? There is a liability to pay rent. Lordship, I put a question to myself. Who can claim the rent? The person who has indicted me? The person with whom I have entered into an
She has
agreement?
died.
No, she has not died. She is alive. Her deposition has been exhibited in the other suit.
Tarini Shah.
Tarini Shah is a male. He died. His wife deposed in a suit filed by us under suit for specific performance. Lordship, that suit is still pending, instituted much prior to this suit.
You see, the suit for specific performance will go on.
No,
But
that
liability to pay, do you
No,
say,
no. Suppose the liability to pay, Lordship holds that yes, there is.
do you say that the vendor of your landlord, the
Yes.
so-called landlord,
Yes.
had no title?
The vendor of my landlord.
Had no title?
No, my landlord was the original owner.
Yes. No. Vendor of, not your landlord. The person who is the plaintiff. The vendor of your plaintiff had no title. Did he have title or he did not have title?
Lordship, at best he can have 50% title only. For the reason, then हम बता देंगे Lordship. For the reason, unpartitioned property, mother admitted facts of the plaintiff. I am not going anywhere. Lordship, mother and son has inherited Tarini Shah's property. It is not in dispute. Lunatic सब छोड़ देते. He purchased.
आप किसको रेंट दे रहे हैं? ये रेंट नहीं दे रहे हैं किसी को.
हम रेंट नहीं दे रहे इनको.
किसी को भी नहीं दे रहे.
किसी को नहीं दे रहे, कोई नहीं मांग रहा.
Show us. So therefore, suit for specific performance will have no relevance with regard to non-payment of rent. That is not an excuse for non-payment of rent.
Suppose non-payment of Lordship, the issue will come. Who will complain? The landlord will complain.
Certainly, you will enjoy and nobody will complain.
No.
Then
I will not enjoy. My money is at stake. Lordship, 2003, the amount of consideration which I had paid. Lordship, the value if compared.
No,
yes.
there is no question of comparing the value because that is for the value of the suit property.
Lordship, at best, Lordship, the widow can claim. Or if a Lordship says for the ends of justice.
Son can also claim. Why?
Son can also claim. Son has, Lordship, son का तो evidence में बोलता है plaintiff. Lordship, हुआ क्या है इस केस में? Son is stressless. उस समय फोटोग्राफी नहीं होता था. 2000
रजिस्टर्ड डॉक्यूमेंट है ना.
रजिस्टर्ड डॉक्यूमेंट में उनका सिग्नेचर भी तो नहीं प्रूव हुआ है. सूट में तो वो लोग इसलिए सूट फाइल किए साइड बाय साइड की किसी तरह पोजीशन में घुस जाए.
ये सब कहानी ना रिकॉर्ड बाहर का कहानी.
Lordship, we have argued on the basis of documentary evidences. They are only relying on oral evidences. Who documents their
oral evidences are to be discarded.
Not discarded, but
is
when
there
documents
any
are
scope of reappreciating the oral evidence in the second appellate stage?
Lordship, the issue of law is, Lordships, where both the courts, Lordship, the case set up by the plaintiff is belied on the face of it and which is believed by both the courts. Lordship, the appellate court will also says that yes, you have been inducted as a tenant prior to Lordship October 2006, which is the date which the plaintiff claims that I had purchased and then I inducted him. He came to me. Suit was in my possession, which got falsified and accepted by both the courts. That no court has disputed that we were not tenants since 1975. Lordship, the judgment which I had cited, Your Lordships, where it says, Your Lordship, that where there are prima facie evidence to show that I was not inducted as a tenant by the plaintiff, but I continued in possession even prior to that. In such circumstances, Your Lordships, our eviction suit as a regular.
Your status as a tenant does not change unless you become the owner of the.
Yes, but I become
merely because of an agreement of sale, your status does not change.
Very well, Lordships. My status does not change, but Your Lordships, my landlord status also do not change barely because another person claims that he has purchased the share from a
the descendant of the. So
what? Lordship, there are two.
There is no legal bar. The co-sharer can sell the property.
Entire property.
We do not know that there could be multiple properties.
No, he says entire property. Lordship, the onus
Entire
is on the
property
plaintiff
means
to
that
show.
may not be the sole property.
Lordship,
There may be multiple
It
properties.
is on the onus is on the plaintiff to show this. Lordship, onus is not on me. When they are prima facie, the plaintiff's case
You
gets.
cannot dispute the title of the
Lordship, his title
vendor
is.
of your.
No, I am not. No, I am not challenging the title of my vendor. I am saying that it was Tarini Shah was the absolute owner of the property. He, Lordships, had the right to enter into an agreement for sale with respect to his entire property after his death. And Lordship, that agreement says, Your Lordship, that I have been put in possession. That agreement has not been disbelieved by any of the court. Lordship, the agreement says I am being put in possession, Your Lordship, as a purchaser, prospective purchaser.
Merely because you are put in possession as a prospective purchaser, that does not mean that the relationship of landlord and tenant ceases.
Lordship, the status changes. Suppose the Lordship, a person.
Judgment थोड़ा देख कर आई है. Status नहीं change होता है.
Lordship, status नहीं change होता है in circumstances, but not in the case where a third party is claiming to be.
So therefore, there is evidence to show that you were paying rent to him and you defaulted.
So that is my admission. In my written statement, I have admitted that my father was a tenant, I was a tenant, I continued as a tenant for more than 40 years. Then we entered into an agreement for sale. After agreement of sale, I was put in possession and I continued in possession on the strength of that agreement. And since thereafter, there was no requirement to pay rent. Lordship, the अगर agreement permit करते, if the agreement is not contrary to law, that will prevail. If the agreement permits the parties, your Lordship, to induct a person as a prospective purchaser on receipt of substantial consideration, and the plaintiff has Lordship, both the courts do not say that plaintiff has proved his case that we were inducted by the plaintiff as a tenant. Lordship, when he has approached the court, he should have approached with clean hands.
When did you, as per the plaintiff, when did you stop making payment of rent?
Plaintiff says that I have stopped in 2008.
Is it an admitted fact or disputed?
It is a disputed fact. We said that we have never paid a single farthing to the plaintiff.
Where is it recorded in the agreement?
Yes. Can you see my written statement itself? Where it has been recorded?
There are two defendants.
Two defendants.
Why two defendants?
They have made us both parties. Actually, our father, Lordship, we are both brothers. Our father was the original tenant. Thereafter, Lordship, we became tenants of the and there was an agreement of sale.
And where is your case that after agreement of sale you did not pay any rent to anybody?
Yes. So that I had just read also, which I was.
Appellate court से बताइए.
Appellate court. अपडेट कोर्ट में पूरा नहीं डिस्कस किया, पैरा 18 में मैंने डिपोजिशन डिस्कस किया है, ट्रायल कोर्ट में लिखा हुआ है.
Where is the discussion of okay, let us take it. Where is the discussion of PW3, 4 and 5 by the trial?
By the trial court.
Because they are the persons who said that you paid rent.
Appellate court में तो Lordship.
Appellate court में we have seen they are supporting the case of the plaintiff.
Yes.
Where
Para
is
15, para 16 that is.
where is the discussion in the trial court judgment?
Lordship, can we come to paragraph?
You see here, यहाँ से है, page
ये
number
page-
14, DW3, deposed.
PW5 यहाँ पे page 11 में भी.
3, 4 and 5, DW5. आप ही के PW का है ये evidence?
उनका DW में ना?
हाँ.
उनका
उनका PW. DW3, 4 and 5. See, there is a full proof discussion. Page number 11.
Yes, I was pointing out that one.
In cross,
In
some
cross report that he has seen the shop, which is at a distance of 2000 meters from his house.
PW3 में आएंगे, ये page number 10 में आएंगे.
PW3 being a witness of same locality deposed that on 1/10/2006, on the eve of Dashera, he went to shop of Mansur Mia and saw Khurshid and Mumtaz were asking Ram Vilas for a shop on rent, and Ram Vilas agreed. Lordship, this has been Lordship accepted to be wrong, Lordship, by both the courts. Both the court accept we were tenant from before. ये just to prove that tenancy October 2006 में दिए थे. Lordship, none of my documents have been disbelieved. So when we were already tenants, why should I go to his shop and ask? Lordship, this has been disbelieved. I can show it from the pleadings. Both the court admit that I was tenant from before. So
No, you were tenant from before, since
Yes.
1966-67.
Yes.
There was another tenancy in 1990.
90. And can you see what he says? He went to the shop of Mansur Mia. Shop, Khurshid and Mumtaz were asking for Ram Vilas for shop on rent. So that occasion was not there. We were already in that shop. कोई डॉक्यूमेंट्री एविडेंस तो रेंट एग्रीमेंट नहीं था. इनको प्रूव करना था कि हमको वो टेनेंट घुसाए थे, इनको खड़ा किए, ये बोलते हैं, and that is falsified by documentary evidences. And that both court
you want to say that these three witnesses were not worthy of
Lordship, not
tenants?
worthy, and Lordship, both the court do not disbelieve my case that I was a tenant. Lordship is also accepting that I was a tenant from 1966.
That's right, but once a new incumbent comes, there can be a fresh
Lordship, he
tenancy.
said, Lordship, something which cannot
Because
be.
that is a case that was set up by the plaintiff.
He set up that I required a shop. I went to him that kindly give me your shop and I will vacate it whenever you want because I don't have a place of business. Then he inducted me. Lordship,
That was his case?
Yes, that was his case. Kindly see, Lordship, I am reading out from his case as recorded by both the courts. Kindly see, Lordship, in the trial court judgment, para 2.
कोर्ट से पढ़ लेंगे.
हाँ, ट्रायल कोर्ट का para 2 से ही पढ़ दे रहे हैं. नहीं का केस. Lordship, running page 40.
Yes.
May I read out it?
Yes.
The plaintiff's case is that shoot land schedule such and such is a self-acquired property of the plaintiff by virtue of a sale deed dated 9/3/2006. Thus, title passed to the plaintiff. Plaintiff came in possession of the
Where
said
is the
property.
substantial question of law?
Yes. So I have prepared also. Can you see Roman 1?
कितना substantial question of law बनाया?
ज़्यादा बनाया 3 कभी बना के रख लेंगे.
Unsound mind का तो हम नहीं बना
नहीं
सकते because there is no proof.
ऐसा कौन से लाएंगे? और जो नहीं हो सकता ऐसा कौन से लाइबल हो सकता?
ये भी unsound mind का बनाया है second number. Third भी आप unsound mind
मैं
का
से one thing. हम कल बना के ला देते रिकास्ट करके. मेरी फ्रेंड है. So the question of law will be framed only as per this judgment, Your Lordship. That is, once the defendants claim that they have been in possession through an independent right through an agreement for sale. So whether the learned court would have decided it under the behavioral reason.
Second appeal number 21 of the third the learned counsel is hearing on behalf of Dapilant. The learned counsel for Dapilant has submitted that Dapilants are tenant in the suit premises and the predecessor in interest of the plaintiff had executed an agreement of sale with respect to the suit premises, and a title suit was going on in connection with specific performance of contract. In connection with specific performance of contract. In the meantime, one of the successors of the original landlord executed a sale deed in favor of the plaintiff, and the plaintiff claimed that he inducted the defendant as tenant in the suit premises upon payment of monthly rental. The learned counsel submits that once the suit for specific performance of contract was pending in connection with the suit premises against the original owner of the property, there is no question of fresh tenancy, as the appellant, who were the tenant, acquired title over the property by virtue of part performance, as they were already in possession of the property. And therefore, there is no question of any default in payment of rent. Even if the property was sold pending suit for specific performance. Correct? Considering the aforesaid submission, the learned counsel submits that this appeal is fit to be admitted on the substantial question of law as follows. A. Whether the appellant acquired title over the property by virtue of part performance of agreement of sale and were put in possession and therefore whether they were under any legal obligation to pay rent to the successor in interest or even to the vendor of the rent. Okay?
So whether the suit would have been decided under Bihar building, that is Jharkhand building lease rent and eviction control act, when both parties were claiming individual right to.
You are not claiming individual right, you are claiming through the same.
Not through the plaintiff, I am claiming through his predecessor in interest. He is also claiming from the same person. He is also claiming the right of Taranisha. I am also claiming the right of Taranisha.
The learned counsel further submits that whether in the fact where both the parties were claiming title over the property, the suit under BBC Act was itself maintained. Considering the aforesaid submissions, this appeal is admitted for final hearing on the aforesaid substantial question of law as suggested by the learned counsel appearing on behalf of the appellant. Issue notice to the respondent through the concerned police station for which requisites be filed by the appellant within a period of 1 week, call for records from the concerned court. Post this case for (27th February) in the supplementary court, awaiting service report. Let this order be communicated. एक आध जजमेंट हम लोग का हुआ है देख लें
जी
आपके अगेंस्ट में, लेकिन फिर भी इसको
यस लॉर्डशिप जो फायदा है
ये आपको बता दो
यस
सुप्रीम कोर्ट के जजमेंट के बेसिस पे लेकिन फिर भी इस तरह के इश्यूज को डिसाइड करना है। Passover. किसका Passover मैटर? आप
Passover case item 6 contempt civil 1071 of 2023.
Already under process, we haven't filed the show cause and yet, but we are already under compliance. Order for regularization of the 4 months petition and ownership.
Why are we not complying?
It is under process. The file is before for approval. Once it is approved within a
किसके
week,
पास है बताइए?
before the concerned minister, the file
Who
has
is
been
minister?
It has been moved for regularization. Once it is approved within a week, we will disburse the amount.
Is there any scope of not approving?
No scope is there, but only we are awaiting for approval. Just 1 week time may be granted. We will comply by the next week, as per the instruction I have received.
कौन मिनिस्टर है? मिनिस्टर का नाम बताइए। किसके पास फाइल पेंडिंग है?
I'll bring it on record.
रेगुलराइजेशन का ऑर्डर है, क्लियर ऑर्डर है, अपील फाइल करके सेटिस्फाई करना।
We are not against the order. We are
Why
complying.
would you comply?
We are
2022 का ऑर्डर है, who will compensate for them? Who will compensate for the petitioner? The order has been passed in the year 2022.
That is for behalf of the but we have taken all steps for compliance. Now, a week's time may be granted. We'll comply the order by the next week. We'll file
The state is not dearth of money. बहुत पैसा आप लोग के पास।
we are just
नहीं, आपके पास पैसा भी है, आपके पास सब चीज़ है, रिसोर्सेज भी है। ऑर्डर कंप्लाई करने के लिए क्यों नहीं? You tell the name of the minister.
I'll just confirm it.
कहाँ पेंडिंग है बताइए?
I'll just confirm it right now.
बताइए ऐसे नहीं होगा। ऐसे रेगुलराइजेशन का ऑर्डर हम जल्दी से करते नहीं है, क्यों हमें तो कुछ बहुत सोच नहीं है।
That extraordinary leave was regularized.
ना भी पैसा नहीं देते। अच्छा, extraordinary leave was regularized. गलती एक हमसे ये हो गया कि इंटरेस्ट का पेमेंट नहीं, ऑर्डर नहीं किया, इंटरेस्ट का ऑर्डर नहीं किया।
There was a liberty granted to the respondents to initiate a fresh proceeding within 6 months. It was not initiated thereafter. The second part of that order, if the proceeding is not initiated, that the period will be regularized and the entitled for payment of the wages. So now since the no proceeding was initiated.
देखिए, Contempt Civil 1071 of 2023. Counsel for the parties are present. Counsel for the opposite party has submitted that in principle the respondents have agreed to do the needful in accordance with the order passed by this court. And admittedly, no appeal has been filed against the writ order. He submits that the matter is pending before the concerned minister for administrative approval. He submits that the matter be adjourned for a week. सोच लीजिए, आपने मिनिस्टर का नाम ले लिया है, ऑर्डर में लिखा हुआ। Post on 13th of February in the supplementary cause list. The compliance report will be filed by 10th of February 25, or at least an affidavit should be filed as to before whom the matter is pending, so that the state authority can be made party in this case for applicable.
Passover case from supplementary list item 11, second appeal 282 of 2023.
पासओवर पहले भी दिए हैं। आपको आपके सीनियर से पासओवर ने एंगेज किए हैं।
कोर्ट नंबर 3 में ऑर्डर्स लिखा है, बस आई नहीं।
अभी आपने किया था ना पासओवर, यही तो पासओवर हुआ।
उसमें एविक्शन सीरीज से
कौन बहस करेगा? फाइल पढ़िए। You are for the landlord or
tenant.
Tenant. Concurrent finding. Correct? Yes, please.
Lord, I beg pardon, I was in court number 3, my lord.
No, no problem.
My lord, I am a tenant, and as against the affirmance, my lord, this second appeal has been filed. Now, on 2 grounds, my lord, I stood evicted by the courts below. One was of personal necessity, and the other was expiry of the lease period. Now, as against the personal necessity, my lord, my humble submission for your lordship's consideration is that the appellate court failed to frame the mandatory issue of partial eviction. Appellate court. Appellate courts, my lord, point for consideration, page 21 may kindly receive. "21 are the questions which were framed. Issues at page 21, my lord. Your lordship sees, my lord, the first question that was framed was page 21.
Yes.
2 issues were framed, my lord, in which there is no issue as regards the partial eviction was framed. So this is my first point for your lordship's consideration, that non-framing of the mandatory issue of partial, because it is a shop here, and the petitioner's appellant's livelihood, my lord, is dependent on carrying of the business from the shop premises. That is the tenanted premises. So non-framing of the issue of partial eviction, which is mandatory, that vitiates the judgment of the appellate. Then, as regards Lord personal necessity, in the earliest legal note, there were 2 legal notices which were given Lord prior to the filing of the suit for eviction. Now, the first notice that was given to me was dated 26/11/11, 26th of November 2011, in which, my lord, only expiry of I was sought. I mean, the legal notice requested to vacate the premises on the ground of expiry of the lease. So, in the first legal notice, there was no, my lord, ground of personal necessity. So, therefore, the ground of personal necessity, my lord, in subsequent legal notice renders the,
What is the date of subsequent legal notice?
my lord, that is at page, I'm just giving, page 38. पहला हुआ 26/11/11 माइनर और दूसरा है 3 and 3rd of January 2012. As mentioned in the page 38-39 matter of the trial court judgment.
It was a fixed term tenancy?
But that also we disputed, Lord. We said that it was not a fixed term tenancy.
It was a registered kirayanama?
It was
for 5 years?
Yes. But thereafter, one affidavit by way of agreement was not sworn in before the notary.
That will not extend the period of tenancy.
So that will be also one of the considerations by this honor. Of course.
We are in second appeal. Just tell us what you want. तो substantial question of law बताइए ये सब नहीं चलेगा. ये partial eviction का बना था आपका issue बना था ऐसा नहीं.
तो partial eviction को तो consider
बना था ना issue.
हाँ वो trial court में बना
था ना.
But the appellate court.
आपने तो नहीं challenge किया उसको. आपने जो आप argue करेंगे उसी पर ना point of determination बनेगा.
क्योंकि हम लोग का तो that was very much there, our contention. And the appellate court is a continuation, Lord. Your Lordship have said, Lord, in so many judgments also, that it is a continuation of the trial. And the appellate court has to exercise its powers, my lord, just as a trial court. The same powers, so he has to go on facts and everything. So the framing of issue, order 41, my lord, rule 31, if I may recall, my lord, that says कि उसमें उसी तरह से trial court जैसे वैसे appellate court को भी points for determination सब बनाना है and the decision thereon. So these are my.
Where is the finding with regard to fixed term tenancy?
Fixed term tenancy, my lord, of the appellate court.
No, of both the courts. You say that you disputed that it was not a fixed term tenancy.
My lord.
Where is the finding? Issue number 4.
issue 3 and 4 are dealt with together. Page 44,
Trial court.
pardon me,
Trial court first.
trial court, page 44. I read from the, your lordship. These two issues, Lord, I read.
You just see page number 49. 49. In the instant case, plaintiff have claimed that the tenancy was created by registered deed of Kirayanama Exhibit 1. The defendant also admitted execution of the same but claimed that the same is not valid. Yes.
Also
You said that
admitted
it is not
execution
valid.
of this
Yes.
document.
Yes.
This
So
is
that's the matter ends. It was a fixed term tenancy. Once there is a fixed term tenancy, the period has expired, you have no option but to evict.
the Lord.
That's all.
Mind. Always enlightened, my Lord.
Essay number 282 of 2023. Heard the learned counsel appearing on behalf of the applicant.
If your lordship permit me, Lord, may I beg?
Yes.
Mind.
The learned counsel for the applicant has submitted that the applicant is the tenant in the suit premises and the suit was filed for eviction on account of expiry of fixed term tenancy and also for personal necessity. The learned counsel has submitted that the appellate court has not framed any issue in connection with partial eviction of the suit premises. He has also submitted that the defendants had also disputed the tenancy agreement. The suit premises is a shop and therefore the judgments passed by both the courts call for interference. He submits that appropriate substantial question of law being framed. The learned counsel has also submitted that in the first legal notice dated 26/11/2011, within bracket Exhibit 3, the defendants were asked to vacate the suit premises upon expiry of the lease period, but thereafter another legal notice was issued dated 3/1/2012, within bracket Exhibit 3/1, stating that he had no space or land or building except the suit premises for establishing his business. After hearing the learned counsel for the appellant, this court finds that the plaintiff had filed the suit for the decree of eviction of the defendant from the suit premises, and also for a decree of damages at the cost of rupees 500 from 1/1/2012 until actually evicted and possession be delivered to the plaintiffs. The specific ground of the specific case of the plaintiff was that plaintiff had let out suit premises to the defendant for a fixed term from 1/1/2007 to 31/12/2011 at a monthly rent of ₹3,000 per month and a registered kirayanama dated 29/3/2007 was also executed, which was acted upon, and the rent was being paid by the defendant to the plaintiff. The suit was taken for business purpose and the tenancy expired on 31/12/2011. As per the registered agreement, the plaintiff had agreed to vacate the suit premises upon expiry of the fixed period of tenancy, and the liability to pay damages at the rate of ₹500 per day was also fixed upon failure to delivery of the suit. The defendant did not vacate the suit premises upon expiry of the period of tenancy. Consequently, legal notice was sent on 26. A legal notice was sent on 26/11/2011 asking the defendant to vacate the suit premises on 31/12/2011, which was duly received by the defendant on 28/11/2011. In spite of that, the defendant did not vacate the suit premises, and ultimately another legal notice dated 3/1/2012 was sent to the defendant by courier and registered post. And in the second legal notice, it was also stated that the plaintiff required the suit premises for his personal necessity for starting his own business. The notice was received by the defendant on 6/1/2012, but no reply was given. And the defendant flatly refused to vacate. It was a specific case of the plaintiff that plaintiff number 2 was an old lady and plaintiff number 1 was looking after his mother and was doing a private job in a bookstore, and he wanted to start his own business of selling books in the school premises. It was suitable for the purpose. The defendant contested the suit by filing written statement. And asserted that the registered Kirayanama was a fake document. And referred to another affidavit dated 23/2007. And as per the same agreement dated 23/2007, an amount of rupees 1,51,000 was deposited with the plaintiff as security, which was interest free. The defendant used to pay monthly rent and was granted receipt, but on refusal to receive the monthly rent of January 2012, the defendant sent the rent through money order. It was asserted by the defendant that the registered agreement was not a real agreement of tenancy and was not for a fixed period. The plea of personal necessity was also contested by the defendant. The plaintiff, the learned trial court framed as many as 8 issues, including the issue number 3 and 4, which was in connection with the registered Kirayanama, which was for a period of 5 years, and also framed the issue regarding bona fide requirement and also the point regarding partial eviction. The issues were framed as under para 4. The learned court considered the evidences on record with respect to issue number 2 and 3 and 4 together, and recorded a finding that the registered Kirayanama was duly executed by the plaintiff and the defendant, and the tenancy of the defendant was for a fixed period of 5 years, as mentioned in the registered document. With regard to plea of bona fide requirement, the same was also considered on the basis of material record, and the issue was decided by holding that the plaintiff number 1 was a salesman and he wanted to do business in the school premises, and concluded that the plaintiff number 1 needed the school premises for bona fide purpose for personal use. The partial eviction issue was also decided, and the court recorded that in the pleadings, the plaintiff had specifically pleaded that partial eviction of the defendant from the suit premises will not satisfy the reasonable and bona fide requirement of the plaintiffs, and there was no specific denial by the defendant of this pleading, and the defendant had not taken the plea that his partial eviction from the suit premises shall solve the problem of the plaintiff. Ultimately, the court concluded that the partial eviction of the defendant from the suit premises will not satisfy the reasonable and bona fide need of the plaintiffs. And ultimately, the suit was defeated. And the plaintiff was directed to refund the sum of rupees 1,51,000 to the defendant, and the defendant was directed to give vacant possession of the suit premises along with rent at the rate of rupees 3,000 per month from 1/1/2012 till the plaintiff to the plaintiff. The appellate court also considered the materials on record and gave concurrent finding. However, the appellate court, while recording the point of determination, had framed only two issues. Number one, whether the plaintiff/respondent had personal necessity of the suit premises or not. Number two, whether the tenancy between the parties has fixed or not. The point of determination was framed on the basis of pleadings, evidences, and contention of both the parties. This court finds that on the face of the finding recorded by the learned trial court that the plaintiff had specifically pleaded that partial eviction will not satisfy the requirement of the plaintiff, and the defendants also pleaded that the defendants did not deny the said position. There was no need to frame any issue in connection with partial eviction, and consequently the appellate court had not framed any issue regarding partial eviction. The fact remains that the pleadings which has been recorded by the learned trial court by rejecting the plea of partial eviction has not been disputed by the learned counsel for the appellant in the proceeding. Considering the facts and circumstances of this case, this court finds that there is concurrent finding recorded by both the courts that there was fixed term tenancy, and immediately the period of tenancy had expired. And there is also concurrent finding recorded by both the courts regarding the personal necessity of the plaintiff, number one. This court finds no question of law, much less any substantial question of law involved in this case. Accordingly, this appeal is hereby dismissed.
Passover case from reading list, item 7, Contempt 669 of 2023.
Filing number?
Filing number is petition 1017 of
1017 of
1225.
2025.
Yes, sir. The same was filed on dated 27/1/2025.
Vicky, Contempt Civil 669 of 2023. Also, for the parties are present. A show cause has been filed by the opposite party, number 2, stating that an appeal has been filed against the order dated 22/11/2022 passed in the BPS number 800 of 2009. provide filing number 1017 of 2025 dated 27/1/2025. The learned counsel for the petitioner has submitted that the appeal is hopelessly barred by limitation. At this, counsel for the opposite party has submitted that we shall take or make all endeavor to remove the defects in the appeal, right? And take appropriate steps for early hearing of the appeal. कितने दिन बाद रखते हैं आपको this?
4 week time maybe.
The counsel for the opposite party prays that the matter be listed after 4 weeks. Post on 7th of March in the supplementary list.
It's a fifth at the Adjournment, may I mention one question? It's a at supplementary list serial number 7 and 8 your lordship. Both the matter was fixed for 4 o'clock lordship. In supplementary 8 we have already filed so was yesterday.
4 बजे बजट.
Lordship, I am just mentioning that we have filed.
मेंशन करके नहीं होगा 4 बजे इसीलिए रखते हैं क्योंकि आप लोग को पहले फाइल करना था अब आप 4 बजे.
We have filed in serial number 8. In serial number 7 that is
आपको
not
नहीं
done.
मेमोरी में रहेगा. आप 4 बजे आएंगे तो ठीक है, नहीं तो we will record your absence.
Passover case item 11 from the list, second appeal April 2 of 2018.
Rising out of a suit for partition which was dismissed under the petitioner, and the appellant before your lordship is the plaintiff, appellant.
On what ground it was dismissed?
It is said that there was a family settlement in 1940 between the brothers, and as per the family settlement, a chunk of land has been given to defendant number 1, saying that Jharkhand is the elder son. That was only, we have to say whether is there any provision for allotting a chunk of land.
If there is a family settlement,
no,
and
that we have denied.
Followed by mutation.
No, followed by that mutation is
Followed by mutation or
part of the, not all the, what is not. I pray one day accommodation if you not space. There is, because the LCR portion of file is missing with me. It is most probably in another file that I was searching. That Jharkhand, only that portion I am challenging, not that share, not a, which was given to the elder son.
और कहाँ लिखा है कि partition जो है equal होना चाहिए?
Equal नहीं.
ऐसा कोई law है
It
क्या?
was given as a Jharkhand.
Yes, certainly it can be given. You see, there is no requirement in law that under Hindu family there has to be equitable partition.
No equitable partition, there is no law.
अब
But
Jharkhand
there
से
is also
1914
no
में
law
दे दिया
that
तो
as a Jharkhand any person should be allotted.
As a Jharkhand का whatever be the name, I just wanted to know from you.
Yes.
Was there any mutation followed by partition?
Certain properties are being mutated, certain property are mutated. The entire property is not mutated between the parties. That I am saying.
From where do you say?
From the judgment I am saying and from other parts. Let it be either tomorrow or next in supplementary list any day.
1000 रुपए फाइन तो हुआ था आपको?
हम दे दिए थे उस दिन. उसके बाद
अब 10,000 रुपए दीजिए.
एक दिन का
जेठांश आपको चाहिए तो 10,000.
जेठांश हमको नहीं चाहिए. जेठांश दे दिया गया, हम लोग छोटा भाई है, हम लोग उसको चैलेंज कर रहे हैं कि जेठांश उसको.
छोटा भाई बड़े भाई को.
हाँ यही छोटा भाई बड़े भाई का जो अंश दिया गया ज्यादा उसी को चैलेंज.
बड़े भाई की रिस्पांसिबिलिटी भी ज्यादा होती है, ठीक है, और ये कोई नया बात नहीं है बड़े को ज्यादा दिया जाता है. ऐसा
हम लोग को छोटा को ज्यादा मिल जाता है, बड़ा भाई त्याग करता है. जहाँ तक हमारा जो पर्सनल अपना ये
ऐसा बात व्यवहार रखेंगे त्याग करने लायक
तो त्याग करने वाला
लड़ाई करने को आ गया.
नहीं तो ये तो आप वही एनी डे.
बड़े भाई का स्टेटस जो है ना
बहुत त्याग का
पिता के समान.
त्याग के समान होता है.
त्याग के समान, पिता के समान.
त्याग का होता है, हम लोग बड़ा भाई है इसलिए देखते हैं. Yes.
आप क्या क्वेश्चन ऑफ लॉ बोल रहे हैं? जेठांश इज एब्सोल्युटली
Yes.
बार्ड अंडर लॉ.
Yes, there is
कौन सा law
no. सुप्रीम कोर्ट एक जजमेंट दिया है, उस पर फाइंडिंग दे दी है कि जेठांश का के कोई अलॉटमेंट नहीं हो सकता. वही जजमेंट हम खोज रहे थे, यहाँ मेरे पास उस वाला फाइल नहीं मिल रहा था. that तो उस पर जो है अपीलेट कोर्ट कहते हैं कि जजमेंट कैन नॉट बी रेस्ट्रिक्टेड।
जेठांस करके कोई सूट में डिग्री नहीं हो सकता।
हाँ वही जेठांस
लेकिन जेठांस करके पार्टीशन तो हो ही सकता है ना, टू पीपल
नहीं,
एग्री कि भाई हमको 1/4
वही
मिलेगा।
जेठांस को ही चैलेंज किया गया, जेठांस जो उनको दिया गया है, लेट इट बी नेक्स्ट वीक, एनी डेट इन सप्लीमेंट्री लिस्ट में डाल, ट्यूसडे को रख दे सप्लीमेंट्री लिस्ट में। Only to that point, only one point is there.
Learned counsel for the appellant has submitted that the matter arises out of partition suit, and the suit has been dismissed on the ground that there was a previous partition. Way back in the year.
Previous family arrangement.
Previous partition through family arrangement. Way back in the year 1940.
Yes.
He has submitted that the sole point involved in this case is as to whether there can be any allocation with respect to any allocation by way of Jethans in favor of the elder member of the family, eldest son of the family. He seeks adjournment to satisfy this court on this point. Let's pose this case on Tuesday in the supplementary process for further review.
Item 14, second April 31 of 2022.
इस केस में एडजर्नमेंट से
एडजर्नमेंट तो नहीं होगा ना,
नहीं, ये तो हम कर रहे हैं।
concurrent finding. Could not be forthcoming. I'm not sure, लेकिन ऐसा लगता है not be forthcoming. पार्टी पोजीशन थोड़ा देख के लगता है कि शायद थोड़ा भी डाउट हो तो करना।
नहीं, हम मेरे नॉलेज में चूंकि फाइल भी नहीं आया,
मेरे नॉलेज में भी नहीं है पूरी तरह से, लेकिन ऐसा लगता है।
सर हम लोग को जानकारी नहीं, सब लोग बोल देते हैं।
I am also not very sure, लेकिन when I am not sure about it, so I don't do it.
Item 15, second to 32 of 2022.
What is the matter? What was the suit for? Cancellation of SATIC?
Yes, sir.
Point of limitation was there? Yes or no? ex parte judgment. Para 10 पढ़िए appellate को जरूर. Read para 10. फाइल नहीं है आपके पास? तो पढ़िए. जोर से सुनाई नहीं दे रहा.
Trial is created by the appellant and plaintiff that the suit land was recorded in the joint name of Ram Chandra Kundu and Vajana Kundu, both sons of Mohan Kundu during the last pedestal settlement operation. It is further pleaded that the said document where Ramchandra Sahu died leaving behind 4 sons, namely Sahu, Milan Sahu and Kilavan Sahu, and the other recorded treasure Vajna Kundu died leaving behind his 2 sons, namely Dinu Sahu and Luchan Sahu. It is further pleaded that in an amicable partition among these descendants of the recorded treasure in year 1989, the entire suit land was allotted in the share Denu Sahu, even exclusive his full brothers Luchan Sahu. After the death of Denu Sahu, his only son Kanchan transferred the entire suit land in favor of the plaintiff appellant by the executing registered deed number 18 184 cell deed number 12454 dated 11/9/1975 exhibit 1, but he has not produced any trade receipt in support of the fact that after the execution of cell deed, his name was mutilated and entered in the revenue register, and after finding him in possession over the suit land, the state issued rent receipt for the same in favor in further appears from the perusal of record that plaintiff has held to prove the CS Kalyan in support of the fact that the suit land was jointly recorded in the same of Ramchandra Kundu and Vaidnath Kundu, the ancestor of his vendor. From perusal of the entire building, it further appears that both the recorded name, namely Ramchandra Kundu and Vaidnath Kundu, were having equal share in entire 16 receiving land, that is suit land, and it further appears that after the death of Ramchandra Kundu, his half share in the suit land divided upon the four sons, namely Nehru, Sahu, Udam, Ram, Jamuna, Sahu, and Kulban, Sahu. And further it appears that after the death of another recorded earlier, Vaidnath Kundu, his half share in the suit land, that is equal to 4 decimal, only developed upon his two sons, namely Danu Sahu and Luchan Sahu. It appears that after the death of Vaidnath Sahu, his share developed upon his two sons, namely Danu Sahu and Luchan Sahu, and they get only their.
Yes, Mr. Banerjee, yes.
Yes. Now the issue which is there, the suit proceeded ex parte. We relied upon a sale deed of the year 1975. That the sale deed was executed in the year 1975 in respect of the suit land by Karamchand, the legal heir of the descendant of the recorded tenant. Karamchand. Karamchand sold to the plaintiff 11/9/1975. That is a registered sale deed, which is Exhibit 1. And according to the appellant, the question of law, substantial question of law, which may fall for consideration is that whether in view of section 54 of the Transfer of Property Act, which defines sale, the registered sale deed is a document of title by which a title is conveyed to the purchaser, and this fact has not been considered by the learned courts below, because the suit was never contested. The genealogy or the sale or the partition which we said in 1959, these facts were never disputed. Had it been the suit was contested and there was some disputes or differences, material differences in the propositions, factual propositions, then things would have been otherwise. But here is a case where the suit was not contested, it proceeded ex parte, but despite thereof, the registered.
What was the cause of action for the suit?
The 2008, the defendants came and started to do some work over the adjoining land. Then there was a 144 CRPC proceeding, that is Exhibit 2, at our behalf. And then we have stated that when they filed the reply in that proceeding, then we came to know that they are claiming to purchase the land by two subsequent sale deeds. That was in the reply in the 144 proceedings. They referred to a sale deed of 1987, the mother sale deed, so far the defendants are concerned, and a subsequent sale deed of 2003, which was transferred by the purchaser of 1987 to the present defendant. So even otherwise, our sale deed is at earlier point of time.
So that sale deed, subsequent sale deed, you did not challenge.
Yes, we made a prayer. When because of that cause of action, because of that 2008 144 when we came to know, we made a prayer. We sought for a relief.
What was your relief?
Yes, our relief prayed for. I'm just reading for the plaint itself. I've got a certified copy of the prayer.
These two sale deeds you challenged.
Yes, that is relief C. First relief was adjudication of title and declaration. That was the primary relief. Second was temporary injunction. Third was declared that the sale deed dated 14/5/87 and 12/4/2003 are illegal, void, without consideration. That was the third relief. And even in this case, independent of that relief C, I would be praying that this is a case where relief A ought to have been considered in view of the fact that there was no contest to the suit and there was a registered instrument which is having the sanctity of law section 54.
Right, section 54.
Yes, and to be read with section 17 of the Registration Act.
Section 54
Yes.
transfer of property.
Yes.
A person who does not have title will also give title.
And that is the issue. Had there been any contest, no one came forward.
No, you see, you have to prove your own case.
That-
There are so many discussions to show that you could never prove your title.
but-
you claimed that there was a previous partition, right? You have not produced anything with respect to previous partition.
59 partition.
You have not produced any document. Nothing.
There I would make a submission.
You see, just a minute. You talked about previous partition. You have not produced. You have not produced any rent receipt stating that arising out of previous partition, your vendor acquired this property. Nothing. Not there.
My vendor was the original recorded tenant.
No, there were two recorded tenants. What do you mean your
The
vendor
original.
was
They were the descendants of the same family.
No, maybe
the
descendants
same
of the
original
same
recorded
family. The court recorded that there was nothing to show that there was a previous partition. There was nothing to show that the property was allocated to your vendor.
There I would refer to order 14. That here is a case where our proposition, since had there been no registered sale deed, I would have not in a position.
You see, you had not you had narrated so much of background in the plaint, but you did not prove any one.
Now the registered sale deed culminates in proving all the said facts.
Registered sale deed is only evidence of execution of sale deed.
No, it is apart from that. It is the recitals. Since it is an admissible document.
Recital is also admissible in law.
68 of the Registration Act. There would be a presumption.
As a presumption.
668, if leadership kindly takes first section 54, it says that there would be delivery of possession. So far as the findings of the learned court below about non-availability of
There
rent
is no
receipts.
delivery of possession.
This registered deed, execution of deed and its registration is itself sufficient evidence of delivery of possession as per section 54 and to be read with section 17 of the Registration Act. These two incidences are there.
What is section 54?
54 is this sale how made. It says that such transfer in the case of tangible immovable property of the value of 100 and upwards, or in the case of a reversion or other, can be made only by a registered instrument.
You are reading 54?
Yes.
54 of?
The TP Act, transfer of property.
The sale defined.
Yes.
Sale is a transfer of ownership in exchange for a price.
Price paid.
Based or promise or partly paid or partly.
And partly. Then sale how made. Such transfer in the case of tangible immovable property of the value of 100 rupees and upwards, or in case of a reversion or other intangible thing, can be made only by a registered instrument. In the case of tangible immovable property of a value less than 100 rupees, and maybe either by registered or by delivery property. Delivery of tangible property, immovable property takes place when the seller places the buyer or such persons as he directs in possession of the property. A contract for sale of a immovable property is a contract that a sale of such property shall take place on terms settled between the parties. It does not of itself create any interest or in or charge of such property. Now, this also recognizes the recital of the.
No, it does not by itself create any charge or interest.
Yes, that is also there.
Yes, that is also there.
So now, delivery takes place when the seller places the buyer in possession of the property.
That's right.
The recital of the sale deed, that which is Exhibit 1, that refers to the transfer of the property, putting the person in
Recital
possession.
of the sale deed cannot be taken to be a gospel truth. You have to prove it.
Because it has a
Execution of the sale deed is proved.
and the recital, since it is on two counts, since it is a registered document, since it is a 30-year-old document, and since there is a presumption under law under section 68 of the Evidence Act in respect of that registered sale deed. So the recital of those sale deeds are itself sufficient evidence to show that the pleadings made in the plaint, which are duly proved. Had it been a case where the pleadings were rebutted, the denial was there, then in terms of section 101 of the Evidence Act, the burden was on the burden was on the plaintiff, the primary burden to prove his case, so far as 1959 partition, and then devolving the property to Dhanu Mahato, and then the legal heir of Dhanu Mahato has transferred the property to the plaintiff. Those things were required, but there is no denial of the said facts. So there is no material differences in terms of, so far as Order 14 is concerned, which says about framing of issues, and therefore the issues have also not been framed, and rightly not framed, it was not required in such situation. But the material propositions were required to be discussed. Had this registered sale deed not been brought on record as Exhibit 1, or had it not been a registered sale deed, a Sada sale deed, then I would have not been able in a position to emphatically make these submissions. But these things, the learned courts below has erred in law in not considering the document, and considering one more aspect of the matter. The learned courts below says that no document of mutation has been brought on record. That so far as mutation is concerned, that is something which neither creates a title nor it in otherwise extinguishes a title. It is only a semblance of possession, and it is followed by a registered sale deed. That is the other thing. So that a document of mutation has not been produced, that cannot disentitle the title holder. If otherwise he is having a title by virtue of a title deed, and that is the main proposition or the proposed substantial question of law according to the appellant, which may kindly be considered by this honorable court. And this has never been considered by either of the courts below.
Second appeal number 32 of 2022. Or the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant submits that the plaintiff had filed title suit number 88 of 2008 seeking declaration of his title and for confirmation of his possession and for cancellation of sale deed on the strength of registered sale deed of 11/9/1975 executed by son of Lochan Ram, who subsequently by executing and registering the deed of sale dated 18/5/1987 transferred the same in favor of the defendant.
Which where
ये synopsis only you have written.
synopsis are just verified.
Synopsis verify करने का कोई काम नहीं है.
Our sale is of 75, so for Exhibit 1, and
just the learned counsel for the appellant has submitted that the appellant had filed suit for cancellation of sale deed number 5740 dated 14/5/1987 and also sale deed number 16122 dated 12/4/2003 as null and void. And also for declaration of his right, title, interest and possession in connection with the property covered by the sale deeds, and also plead that in case the plaintiffs are found dispossessed from the property, appropriate relief be granted for recovery of possession. The learned counsel submits that the plaintiff was claiming title over the property by virtue of registered sale deed dated 11/9/1975 within bracket Exhibit 1, executed by one Karamchand. The learned counsel has submitted that the suit proceeded ex parte and the cause of action was when the defendants claimed title over the property. And a proceeding under section 144 CRPC was also initiated. In the year 2008. The learned counsel submits that the sale deed of the plaintiff was of the year 1975, which was 30-year-old document, and therefore the recital of the document is also presumed to be correct. He has referred to section
68 of the Registration Act.
68 of the Registration Act. He has further submitted that the entire fact regarding partition amongst the family of the vendor of the plaintiff way back in the year 1959
Yes.
was narrated in the sale deed exhibit 1, but the learned court has, but in spite of such presumption, the learned court has refused to decree the suit, primarily on the ground that neither the property was mutated in the name of the vendor of the plaintiff, nor the same was mutated in favor of the plaintiff, and has held that the amicable partition itself was not proved. Correct?
Yes.
The learned counsel submits that once the sale deed was registered and the document was 30 years old and the suit proceeded ex parte, the learned trial court ought to have decreed the suit. He has also submitted that the appellate court has also not considered this aspect of the matter, and therefore, though there are concurrent findings, but this appeal is fit to be heard on by framing a substantial question of law. That's all. Arguments concluded, orders के लिए रखेंगे. हमको करना होगा तो हम फ्रेम कर देंगे, नहीं तो हम डिस्कस करेंगे.
The proposed substantial question.
I've seen it. It is already there in the record.
BC, and I'm just referring. B, C and F. B, C and F.
The learned counsel has referred to the substantial question of law as proposed. That is substantial question number B, C and
F.
F. $74 क्यों लिखे एविडेंस एक्ट में?
वो तो वही कि it is about a public document and does not require any other formal proof.
The learned
Otherwise,
counsel
it
has
is marked
also
exhibit
referred.
one.
The learned counsel has also referred to section 74 of the Indian Evidence Act and submits that the registered sale deed is a public document and it does neither its execution nor its content requires any formal proof. यही आपका case?
74 में execution का ही खाली आएगा तो document में execution. बस we are
तो 74 उसमें लिख के क्यों आप इसको आने से इसमें तो 74 लिख
the basic thing which we are proposing is that the courts will have committed error by not considering the registered sale deed as a title document when there is no rebuttal of the pleadings made in the plaint and there is no rebuttal of the facts about the genealogy or about the partition said to be effected in 1959 and thereby the courts below have not considered section 54 Transfer of Property Act, section 48 of the Registration Act and section 90 of the Evidence Act. Three provisions were lying. Section 48 of the Registration Act and section 54 of the Transfer of Property Act and section 90 of the Indian Evidence Act.
48 क्या है?
48 is about effect of a registered document over other oral testimonies or something. So it gives a legal sanctity to the contents of a sale deed, to the recital.
Section 90 Evidence Act
Is about 30 years presumption. The authority under law to presume about documents
The
30 year
learned
old.
counsel has submitted that the learned courts have not considered section 48 of the Registration Act, which gives credence to a registered document, and has also not considered section 54 of the Transfer of Property Act, which defines sale, and further not considered section 90 of the Indian Evidence Act, which deals with presumption regarding 30-year-old document. That's all. Wednesday for this.
Item 16, second bill 39 of 2022.
Yes, appellant.
Your Ladyship, this matter has to be argued virtually. I am outstage.
Yes, Your Lordship. I'm so sorry, Your Lordship. I'm appearing through VC. My Lord, I'm appearing in this matter for the appellant, and I'm just seeking for a very short accommodation for the reason that I've just been engaged for the arguments on this matter, my Lord. So I have gone through the file, and I think I would require to address issues on the point of law, my Lord. So I would be requesting at least 4 weeks' time to address on those issues.
There is already an adjournment granting you last chance.
Your Ladyship, we have filed the present Muqaddama around 2 weeks back.
You seek the cost from your client. We are not concerned when you enter appearance.
My Lord is not audible, not able to hear.
You see, there is already an order by way of last indulgence, and you are seeking time today. Once there is an order of adjournment by way of last indulgence, I will give you time like this.
Yes, ma'am. Yes, ma'am. Now it's all.
See, there is already an order of adjournment by way of last indulgence.
Yes, ma'am. Yes,
And
ma'am.
you are seeking time today.
No, I completely agree, Madam, because I have been, Mr. Ranjan is there, he apprised me that he's also filed the Wakalatnama quite recently, and the previous council has been, he has given his no objection to that extent. Madam, I'm just seeking, because I have just received the file a couple of days back. It was sent through me by courier, so I would be requesting at least 4 weeks time, Madam. Next date I would be there before your lordship. Physically, I will try to be there and argue this matter.
Since you are appearing for the first time before this court, I must make it very clear to you
Yes, Madam.
that here adjournments are granted only upon payment of cost.
So,
You will not impose cost since your first appearance.
Yes, Madam. I would be grateful, Madam, because I'll definitely be
But
there.
I
Madam.
would
Just-
also remember, and you should also remember.
Absolutely, Madam. Madam, just one request. If a specific date can be given so that I am there.
Every case has
for
a
your-
date. In our court, every case has a date. You choose your date. Which date do you want?
Madam, 19th or 20th of March, if that could be as per the court's convenience also, Madam.
Okay. Essay number 39 of 2022. Your name, please.
Jayant Sarkar.
Mr. Jain Sarkar.
Jayant.
Address.
I'm
Sorry.
so sorry.
Jain Sarkar.
Madam, CHAYA, yes.
Now, Mr. So and so appears online, and Mr. Naam Apna Bhi is present in the court. The learned counsel for the appellant seeks adjournment by submitting that he has been recently instructed to argue this case. Upon being pointed out that the case was adjourned on 28/11/2024 by way of last chance, the learned counsel has submitted that he needs some time to prepare and the matter will be posted on 19th of March.
Yes,
And on
sir.
that day, he shall not seek any adjournment. Post this case on 19th of March 25 in the supplementary business.
I'm so grateful.
The prayer for adjournment will be granted if any such prayer is made upon payment of cost of ₹10,000. अभी से cost आपको बता दिए हैं कितना लगेगा.
Yes, Madam. I will definitely be there, Madam. I will abide by what I have said. I'm so grateful, Madam.
Item
I
seven-
have the possibility.
Item 17, second appeal 14 of 2022.
Yes.
There are three issues, Lords. We have lost in both courts. We were claiming that the land came to us pursuant to surrender made by the Rayat to the Zamindar. The appellate court holds that the surrender is in contravention of section 70 of the CAT Act, hence void, and I have not been able to prove my possession. My case is in the
Why
alternate.
would Zamindar surrender?
The Rayat surrender.
Rayat surrender.
Rayat surrender to the Zamindar. So anything has to be with the permission of the DC in terms of section 72 after the 48 amendment. So it is post 48, the court records that there is no, it is in contravention, hence void. And the court also says that I have not been able to prove my possession. Now your Lordship kindly has a look at the order which was passed in this case earlier, where 24/1/2020. This order, so in second, 24th of January.
Yes.
We had relied upon Exhibit 9, which is an order passed by a single bench of this court in a mutation proceeding which records that I am in continuous possession. And that document, despite being exhibited, has not only been considered, but a finding contrary to that has been passed. Now it's a order by the High Court in a
Did you
proceeding.
set up a plea of adverse?
Yes, 100%. I set it up.
No issue frame.
Issue not framed, but it has also finding is there. So finding is that inconsistency in my case. So these are the
This document has not been considered.
not considered at all. Rather a finding by the lower appellate court notes that
Which is that exhibit which has not been
Exhibit 9 of the trial court, Exhibit 9, I just saw the judgment of this court. Sorry. The relevant portion is this.
It is one thing that it has not been considered, and it is another thing that it has been considered and rejected.
But there could not have been a consideration of an order passed by the court, that was superior court, contrary to what has been said. Kindly have a look at the underlying portion that I am in continuous possession, and I will take your lordship through the lower first appellate
This
court.
was passed
executed.
in your case.
This is in my case, in respect to the same land. In a mutation proceeding, in respect to the same land. A mutation case, possession is an important factor. It says I am in continuous possession, and the lower appellate court, first
Then
appellate.
what was the occasion to file a suit? There is already
Because they executed certain sale deeds in favor of third parties. We wanted a sale declaration that the sale deeds are not binding on me. That's the remedy available to me. Those registered sale deeds have to be, a declaration has to be sought for. Since a cloud was cast over my title, I had to institute this suit. And
this was exhibit 9.
Nine. Now, kindly come to running page 61.
This exhibit 9, this judgment will be binding on everybody.
But at least so far as my possession is concerned, it's a fact, evidence of possession.
No, but even if any observation or finding has been recorded by the learned writ court, it will bind everybody.
Because generally the courts, this is in the writ jurisdiction.
No, it will not bind everybody.
It may not, but the factor of my possession, how do I then prove? If I have a high court order.
So I just want to know where is the discussion regarding mutation?
Kindly.
Because this finding is based on mutation.
Yes, I just request your lordship to come to page 61, running page 61, kindly. Just one line I want to show and then get back to the question. Page 61, the last paragraph. On the above point, I find that the alleged surrender is void in absence of prior sanction of DC. Hence, there is no question of further settlement of land by the landlord to other settlement. As per respondents, they are the legal heirs of Vishram Munda, who is the record of rights, and they are in continuous possession of the suit. In the case, I find that the appellate has failed to prove that they have possession of the suit land. This is what a countering.
What was your evidence led with regard to possession?
But this order.
No.
5, 6, 7, 8, 9. Rent receipts are there, the order is there. What more do I need? When the High Court says I am in continuous possession in a mutation proceeding, how can you not consider? Your lordship is right.
Continue in the second.
Second.
I would
Matters are fixed in the second.
We can continue this as a first case and then.
Right, I'll be here.